Welcome to my channel, All for Health with Jane. Family, the AKA and Tibz murder case continues. We are watching and listening to the legal representative for accused number 3 as she is presenting her arguments, reasons why she feels accused number 3 must be granted bail. Family, sit and relax. Listen to this advocate as she is presenting to us so many cases that are scary that this young boy is facing. Let's listen.
As a reminder, by the way, how many charges is he facing other than this one?
How many matters?
How many matters is?
Usually there are 4 matters. The one is in Chatsworth.
4 matters. Just tabulate them.
I will do. The first one is in respect of firearm possession, and that is now in Chatsworth. It's actually an Umlazi matter, Umlazi Regional Court matter, but the court is sitting at Chatsworth Regional Court because of the facilities.
Possession of firearm.
Yes. Then there is a second matter that my client is on bail for in DC 10. That will be for possession. I think there's a myriad of charges in respect of a shooting incident in which a person passed away. It's alleged to be a taxi-related incident, Your Worship.
But what is the charge?
So it'll be murder, attempted murder, possession of firearm. I think in that one there might be an allegation. No, I think that's as far as that is. Then there is
that is 2.
That is 2. The third one is the matter in DC 11. We're nearly finished with the bail application. We're ready to file ahead, Your Worship. That is in respect of murder, attempted murder, possession. Also MI2P in respect of holes in the vehicles that sustained the gunshots. Not money laundering or anything to that effect, an attempted murder, and also failing to assist a pedestrian that was injured. So it is also in relation to a shooting incident. It's a murder matter, and conspiracy, that is now in DC 11, Your Worship.
That is 3. 4?
This is the one that we're dealing with here, Your Worship.
Which is murder.
Which is murder as well, yes, Your Worship.
Now the question that comes to mind is propensity.
Your Worship.
Or alleged propensity?
Yes, Your Worship. In this regard, we're sitting with an applicant that has no previous convictions, no pending cases. At his age, he walks in, the first matter he is arrested for, all linked to all these matters. This is the Umlazi matter last year, April, Your Worship. At that time, and this is where my client's position comes into play at this point in time, having 4 matters against him. At the time, and it is so in my affidavit, the investigating officer says, clearly, during the bail proceedings, it is the firearm that's linked to these 7 offences, and that is why he's opposing. And he lists the 7 incidents of murder. And the magistrate had said, so the applicant is linked to these 7 cases of murder, and Mr. Parbu then corrects her and said, no, Your Worship, the firearm.
Yeah, but the question is still standing.
Propensity.
Propensity to be linked with violent crime where there is a loss of life.
Yes, Your Worship, but that is where I'm saying that my client was then subsequently piecemeal arrested on all the other cases in that affidavit, where he was not linked to it. This is a roundup of usual suspects, Your Worship. There is nothing at this point in time that links my client to any of these matters. He's on bail on 2 of these matters.
Ms. Gilling, how can you say that? Are you in possession of the statements?
I'm not in
the content of the docket?
I'm not in possession of it, Your Worship.
So how can you say there is nothing that links your client if you're not in possession of the content of the document?
We've dealt with the state's submissions on what they have against my client. And as much as the state can say they have a firearm that links my client, the state is, the defense is disputing that because we've addressed that firearm. And we said that firearm is not linked to this matter. And that firearm is not linked to my client. It was just that 7 persons were not in a home, not on a homestead, in a building at a tavern, arrested for those initial 2 firearms. 1, I don't know where that gentleman has gone to. 5 were released. 2 were then charged. And then they're saying my client is now linked with the firearm, with all the offences that is alleged to belong to the firearm. It is not so that it could say that my client has a propensity to commit crimes, when all that is before court now is allegations that he's linked to a firearm that is linked to offences. That is all that's before court. It doesn't show that my client is a habitual criminal or there is a violent man, Your Worship.
I'm not in a position to say that he is a habitual criminal. But the question that comes to my mind is, a person who is alleged to be involved in 4 matters that are violent related, where there has been a loss of life, is the conclusion, prima facie, that he has a propensity of committing violent offences or to be linked with violent offences escapable?
No, Your Worship, I would differ. I would say, had there been previous convictions, yes, then one would say you can conclude that the person might be a person that has a propensity to commit these crimes, but there's no convictions we're speaking of here. These matters, the evidence is not tested yet.
So all these 4 matters are before courts?
And it all happened within 1 year. The arrests. Yes, Your Worship, that's
but
correct.
They are all before courts?
They are all before court, Your Worship.
In all 4, he is an accused person?
That is correct, Your Worship.
And you say propensity does not apply?
It cannot possibly apply because he's not been convicted. To be arrested for an offence does not equate being suspected of being the person that committed it, unless...
The word in this context, propensity, is used in what context? Is it propensity to be convicted of offences, or is it propensity to commit crimes?
What the question would be, what points towards a propensity to commit offences?
To commit offences?
Yes.
Not to be convicted of offences?
Yes. But what points to the propensity to commit offences is the amount of times that you have been convicted, found guilty of them, not the amount of times you've been rounded up with a whole bunch of people as a suspect.
Why are we saying propensity to commit? Why are we not saying propensity to be convicted?
Propensity to commit could never be deduced or presumed from arrest, Your Worship. It has to come from something factual. It has to come from convictions.
See, I'm not arguing the case for the state. I'm raising this question for my own benefit, because at the end of the day, I'm the one who has to give judgment.
I understand. That's correct.
There is or there is not. I don't know where the state is going to raise this point, but I'm raising it as an officer of the court. Here you are, 4 matters against you. Are we not having here a case of a propensity to commit offences? Then I'm expecting you to address me on that. Is there no propensity, or there is propensity?
There could be no propensity unless the state is bringing something to the table that shows my client had committed these offences, and there can't be a presumed propensity, Your Worship. Especially not in these circumstances. There are various cases that's coming in and out of this court and the courts around us that are now, and it's been televised, that are now linked with one another. The Chatsworth case is now said to have gone to, it's adjourned to 10 June to maybe be consolidated with this one. So, or another one. So at this point in time, the state is grappling, maybe, and the one in DC10, for which my client is on our bail as well, my learned friend had also indicated that is being adjourned to be consolidated with these other matters. So ultimately, perhaps a mistake was made affecting different arrests for various leads, making it appear as if there are 4, 5, 6 different cases, different persons for each case, where it should have been one arrest in one case. That's the only reason I can prefer to court of why my client is now sitting with 4 pending matters, because I've already been told DC10's murder matter, it's going to be consolidated with this matter. Chatsworth matter is going to be consolidated with this matter. So then in that instance, it is not applicable now, but that then falls away. And it's just all one matter. So in essence, I can't say, unless my client is convicted or carries previous convictions, the presumption or the presumption of propensity cannot be said to be applicable here if there's arrests. Arrests are not going to point to guilt in this matter. They are confusing the matters as well, Your Worship. I get confused when I sit in DC-10 and my learned friend said to me, we're consolidating this one with the other matter. I'm saying, on what basis? And they won't disclose the basis either, Your Worship.
We can argue about this in chain comes earlier.
That is correct, Your
But
Worship.
the question that comes in,
That
goes
was-
down is it propensity to commit offences or is it propensity to be convicted of offences?
Yeah, there's neither, Your Worship. There's no propensity to commit offences. There's nothing before court.
Is it propensity to be convicted of offences?
It's a propensity to be, in essence, my client's dad was a taxi owner and he passed away. So I think it's a propensity to be rounded up as the usual suspect when taxi violence happens, and not all of them, and actually quite a few, do not land up at trial, Your Worship. More often than not, charges are both drawn against half, more are added. So I would rather say it's a propensity to be rounded up as the usual suspects when there's violence in that area. But it's not a propensity to commit offences, Your Worship.
And I read your found an affidavit some time ago. I did not have time to revisit it again lately. Exhibit
C, Your
C.
Worship. Yes.
Am my understanding meant to say that there is the state case against your client is weak?
That
And
is correct,
also
Your
going to be applying for discharge in terms of section 174?
No, most certainly not a submission in my papers that my client will be asking for discharge in terms of section 174, but during trial. But my submission is it's weak, it's exceptionally weak, and there are further considerations in my founding affidavit saying that the High Court has already considered this matter. It saw the affidavit of Mr. Padbu. It saw the record. It knows about this. My client has been released on bail on 7 matters. On the founding affidavit, there's the High Court order. Attached to that is the record. The exhibits is my client's affidavit, the founding affidavit of the investigating officer, and that founding affidavit clearly says there's 7 other cases, and the High Court yet still granted my client bail on appeal.
That's not where I'm going. Where I'm going is, am I understanding you to say that there is a weak state case against your client when he is alleged to have been found in possession of a murder weapon a few months after the murder was committed?
Yes, Your Worship. It is most certainly my submission. The submission in respect of that is, firstly, if you have a firearm that's alleged to be linked to 7 or 5 offences, say around the coast, these firearms might, or this firearm might have been in possession of another person at another time. So it's not to say that if this firearm, that's why Mr. Padbu had corrected the magistrate and said, no, it's a firearm that's connected to these offences. He didn't want to commit to say it's my client. My client was found in possession of the firearm, allegedly so. That firearm is now linked to this matter. And I've already addressed that in my affidavit, saying it's not the same firearm. The state has already said the second firearm in this matter has not been recovered. And as there's an argument that says the one firearm is sitting with the Chatsworth matter and the other firearm my client is charged with, it is incorrect, Your Worship. So, no, I would say...
That is why I'm raising this, because you are saying your client will be discharged in terms of section 174. Will he not be called upon to come and explain his possession of the firearm? That is, if it is proven that he was found in possession of that firearm, because that is what the state is alleging. Does 174 feature here when he is found in possession of a murder weapon and he does not have to explain his possession?
Your Worship, in essence, maybe a Section 174 discharge, that's upon that minimum evidence upon which a reasonable court could convict and put him on the back foot in case he incriminates himself. Your Worship, then if he's not granted a 174 application, then he most likely would be in a good place to close his case and then have the state.
But you say in your founding affidavit, I will ask and I will be granted 174 discharge.
I did not say that in my founding affidavit, Your Worship. I
You
think
did
it's
not?
another. It was another one. It was for another applicant, Your Worship.
Okay. So
I
are
wouldn't
you
push it that
prepared
far.
to concede that he may have to explain his possession? Because
he might.
it's not in all murder cases where a murder weapon is recovered and found.
That is correct, Your Worship.
Yes. So if you are found in possession of a murder weapon, you need to explain your possession, and the doctrine of recent possession also come into play. Is it not so?
Yes, that would be correct. But I was not the person, and my client was not the person that alleged. I think it was my learned friend, Mr. Nglocha's affidavit that said that he will be granted a discharge. I did not allege that in my affidavit. But while the court had asked me that, I had said, I was sort of caught off guard, Your Worship. That was one of my submissions, my client's submissions. Any further questions from the court? Your Worship?
No. Anything further you wish to say?
Nothing further, thank you,
You're
Your Worship.
not an accused, you're not a witness. I'm just asking you to assist me, clarify some points.
No, thank you, Your Worship. The court had me sweating bullets now. No further submissions. Thank you, Your Worship.
Mr. Ferguson,
Family, this boy is very young for all these allegations. You know, much as his legal representative is trying to sugarcoat this by saying, no, he's not linked, he's not, whatever terms that she's using to try and protect this boy, or maybe try and motivate the magistrate to grant this boy bail. He's still very young for all these things. He needs to repent. He needs to think otherwise and do the right thing, family. One cannot live by crime. For you to put bread on the table does not necessarily mean one has to rely on crime. There are other ways, there are other means where you can put bread on the table without spilling any blood from any other person. So, but anyway, family, thank you so much for watching this video to the end. Like it before you leave. Subscribe for my channel if you haven't done so yet. Thank you, family. See you on my next upload. Bye.